funky. We're going to start getting into details and start trying to hash out more of the specifics of the things that we want to make recommendations around. Today, we're going to do a little bit of a refresh and recap of our last conversation when we talked about emotional distress. We're going to move into a conversation around caps and the modernization of dollars. Ian has provided us with some background information that I will talk a little bit about. We didn't want to rush and send it out the morning of the meeting, but that takes a look at other states' caps. So we'll have a conversation today, brainstorming and understanding the background on caps and the conversation we've all identified about modernizing dollars. Then I want to spend some time really digging into the stakeholder outreach process and getting into the weeds with all of you about who we want to engage and what specifically we want to ask them to help inform the conversations we've been having on things like emotional distress, on things like caps and modernization of dollars. I will also preview for you that I think there's going to be some requests coming from some of our other subcommittees back to this subcommittee as they do their work, looking at things like the inventory of accessible housing, which raises questions of what is the legal definition of some of those things. So while we've talked about rewriting existing law and addressing existing definitions, I think there is a strong likelihood that I want to preview at the end of today's calls about some of the other things coming from our groups around government access, around access to the electoral process, around access to the outdoors and recreation, and around the housing needs. But before we get into new conversations, we're going to do a little bit of a recap. And as I do at every meeting, I will just once again ask everybody to refrain from using the chat, which can become distracting for all members, particularly members who are using screen readers or other technologies. And a reminder when you speak, the first time to give a full introduction, and as we go through the conversation, just anytime you speak, to introduce yourself at least by first name. But similar to what we did on the last call, what I'm going to do is ask everybody to just share something that you took away from our last conversation if you were on the call when we were talking about damages for emotional distress. Whether that was something that you heard from one of your peers on this subcommittee that really stood out to you, or a thought that you walked away with. And if there wasn't anything that really jumped out, or if you didn't have a chance to be on that call, would love for you to just share your thoughts coming into today's call about the work that we're doing. And Andrew, not just because you're the lawyer with a lot of knowledge, but because you're the top corner of my screen, we go to Andrew Montoya first and then over to Alana.
All right, thank you, Barrick. This is Andrew Montoya. One thought that I kind of went away with after our last discussion about emotional distress damages is that some folks in the group seem to view emotional distress damages as a remedy to make people whole. The person who suffered the discrimination gets this money, for lack of a better, a better way of doing it, gets this money to make them whole for the discrimination they suffered and the distress caused as a result of that. Others seem to view it as more of a punitive thing on the business. So, we're punishing the business by taking these dollars away from them for them doing something bad, like discrimination. And that's kind of that seems to kind of be the dichotomy that's the disconnect between the two kind of groups, so to speak. That may be an area that we need to spend some additional time is how we actually view, the emotional distress damages from the outset.
Great point. I appreciate you highlighting that, Andrew. Alana and then Tom.
Thanks. Yeah, this is Alana. One thing that kind of jumped out to me was that, especially as we're discussing things like caps and things like that, I caught myself repeatedly assuming that any damages implemented would be those caps. Those are the numbers we're talking about, and therefore that's what's in my head. But obviously that's really just the upper end of the spectrum that a jury would then decide. So that's something I'm trying to be more aware of for myself, is that this is really just, we're helping define the spectrum or discussing what the spectrum should be. We're not saying this is what the numbers in the actual cases would be, if that makes sense.
And Alana, thank you. And I want to be clear with the group. That was among the questions that you all identified where you'd like some more information. What are the damages that have been sought? What has actually been awarded? I don't want you to think that we've lost that. As you might imagine, with 4 subcommittees addressing such complex issues, our research list, I think, is now into the triple digits. So we've been prioritizing pieces but that is something that Carrie is working with the DORA team and the research group to identify. So we will be bringing that back to our upcoming conversation where we start trying to outline our thinking. We'll make sure it's informed by that data that you all have asked for. Let me go to Tom and then to Lauren Schwartz. Tom, your takeaways or thoughts from our conversation around emotional distress damages?
Tom Aker, my thought, well, I'm kind of all over the place. I'll be in admission, trying to figure out how do you gauge what is emotional distress and how do you compensate for it. Just trying to get my arms around that. I'll just be openly honest about it. So still trying to figure out and really, get a good understanding of how it's gauged and how it's applied.
Tom, I appreciate your transparency. I'm going to ask a question of you. And part of what we've tried to do in structuring these calls is to have both some left brain and some right brain conversations. So to date, it's really been brainstorming in the big picture, how to tackle this. As I said, as we go over the next few months, we're going to really start digging into getting technical and starting to put some language on paper for recommendations. What would help you or be helpful, you think, to you and to the group's conversations to get your hands around that?
I think the research that we've asked you to look at and maybe some case studies that are examples, and a little bit more into the why, I guess, would help me and possibly help others in the group.
We will prioritize that and make sure we have it, and then we get things to you in advance of the conversation when we are going to ask you to start workshopping solutions and recommendations. Let me go to Lauren and then Cindy with either takeaways or current thinking on the topic of emotional distress damages.
Sure. Lauren Schwartz. I work with the Colorado Chamber of Commerce, and I am here representing business today. My takeaways from the last discussion, the biggest ones, number one, I learn a lot every time I meet with this group of amazing peers who bring so much more knowledge than I have to the discussion. But one of my takeaways was we weren't any closer to having a resolution or consensus on a recommendation. And I'm not sure we will get there. Since that time, I've learned of a case that has nothing to do with, well, I shouldn't say nothing to do, but didn't have to do with Colorado Anti-Discrimination Act, but a case where an individual was awarded by a jury $30 million. And because of our statute that did not include non-monetary damages, emotional damages, that was lowered to 10 million. Those kinds of suits, I don't think can ever get paid because the company will go out of business. They don't have that kind of money. And it leaves a question in my mind of how does the jury come up with those kinds of numbers? Whether it's emotional distress or anything else, So I actually want to echo what Tom said. Tom, you're not alone. I have the same questions. How is this measured? And it seems it could be very subjective depending on the jury. So in any case, my last thoughts.
Thank you, Lauren. And in addition to that data and research, as I said in opening up the meeting, one of our blocks of conversation today is going to be about what conversations we need to have with additional constituents, additional Coloradans. So we're going to really try to dig into that with you of who do you believe we need to ask and get more opinion beyond the empirical research? Whose perspective do we need? And what specifically do we want to ask them? So we'll spend some time on that. Let me go to Cindy and then Courtney. When I come to you, I'm going to pivot the question a little bit since I know you weren't on the last conversation, but I want to get your thoughts on it. Cindy, on the issue of emotional distress damages and our last conversation, what were your thoughts walking away from that discussion?
Yeah, so this is Cindy. For folks who may not recall, I am a deafblind individual representing, individuals with disabilities. as others have said, our discussions are always very insightful and enlightening. This is not an area, as I've mentioned before, that I am well versed in. However, my concern is that, the disability laws and the enforcement of anti-discrimination is so not working in Colorado that, when it comes to things like emotional distress being considered, this is one of the few options that we have. And with all due respect, I understand that, a jury making a decision of, penalizing a company with $10 million is extraordinary for most companies, with a couple of exceptions. I too am not sure about how those decisions are made, because in my mind, it's like, there's a difference between a small business, whose operating budget might not even be 1 million for the year versus, Google or Apple, etc., Microsoft. So I don't know if those types of things are considered, and that goes back to my ignorance on these issues. I am concerned that I feel that this committee, we need more information. I understand the issue with the backlog on research. And my question is, A, do we have enough resources to conduct the resources needed by ours and other subcommittees? And B, is it possible that once we, create a list of what we need to thoroughly consider a matter, should we table it and come back to it and work on other lists? That's just a thought.
Cindy, I appreciate your thoughts on the topic and your questions on the research. And I think the answer is I would probably never be satisfied with the amount of research we can do. That said, I think we are moving quickly. Dora's team is themselves each taking it on. They're also actively working to hire a dedicated researcher for us. And that's why we're going to follow exactly your suggestion is have these initial conversations, identify the research, and keep moving some of the other conversations while we get that research collected. I just also want to keep it on everybody's mind as we go through. If you're like me, I never in college could remember what I studied last semester. I don't want us to have one conversation and not talk about it again for another 3 months and forget everything. But I agree with you wholeheartedly. We need to make sure we're having these conversations when we've got the research, and Dora's team is doing a huge lift to do the research while also trying to hire additional time-limited staff to help with this.
Sure, thank you.
Yeah. Courtney, I'm going to bring you in, knowing you missed this conversation last time, but I think you're getting a sense of it. We had a lot of conversation about people talking about these types of emotional distress damages are often for situations where you can't bring back the opportunity somebody was discriminated and missed. And there were things like missing a child's graduation that you can't wait and see if, well, maybe the next time your child graduates is something, and that there are real damages associated with this. There were also some folks that brought up the issue or the question of, is there a difference when it is ignorance versus malice? Does it matter? And how do we set these? And as you're hearing from some members, people wanted to know, irrespective of limits, how much is actually awarded in different cases. So we're working to pull that together. But Courtney, I would love your thoughts on the question before the group has been, what should Colorado's laws be on the right to seek emotional distress damages in discrimination claims?
So, and this is Courtney Patterson. I'm an attorney, and I primarily represent business interests when they've been sued for ADA violations. I guess the piece that you just mentioned about whether it was ignorance of the law versus malicious or willful in terms of a violation, I think that that's a really important piece. And I think it's hard, and that's why they put caps on things, because every case is different and every circumstance is different. And so there is a potential for abuse. There's a potential for these astronomical sums of money being awarded without really any rhyme or reason as to why that is. And I think that's why it's important to have caps. But beyond the caps, I do think it's important to define or further delineate the type of conduct at issue. And so, should somebody who's just ignorant of the law, be penalized the same way as somebody who's maliciously or willfully or wantonly causing the discrimination. And so I think that that's important. And it sounds like something that we're going to get into. I think that there is a difference obviously between emotional distress and then punitive damages. I don't know to what extent punitive damages are part of our calculus when it comes to doing these rewrites and these edits or proposals. But I just think that there just always needs to be a sensitivity, not just for the person who's been damaged or injured by the conduct, but also for the person who's engaged in the damaging conduct, right? Like, I think there needs to always be a mind or an eye to both sides, and really trying to understand what went on, as opposed to just, well, there was discrimination, therefore, this person should be slapped with a really significant penalty. I don't know if that in any way answers the question that you asked, but those are my thoughts on it.
No, it does. Thank you, Courtney. And the discussion that we had on our last call was the fact that given the federal Cummings the decision that came down, there isn't a mechanism right now in law for seeking and pursuing damages for the emotional distress. And the question before us is how to address that in Colorado law in the interim, in the event that the feds don't do anything to address that. The other issue that you started to touch on around caps and amounts is the next part of the discussion that we're going to have. I appreciate everybody's candor and the honesty here. And I think we will continue to prioritize getting the research on what has historically happened and bring that back. We're going to talk later about who else we need to listen to, but you've laid out exactly, up until now, we've had, what do you think? And it's been very respectful in not responding to or countering or trying to debate it. Frankly, while I'm going to, expect we maintain the civility, going forward into the spring, we're going to go into debate mode because we're going to need to start putting ideas on the table and hashing out what are the strengths, what are the concerns, and what's the right thing to do for Colorado. So I think we've heard a microcosm of that. We're going to really get into it as we start arming you with some more research behind that. Before I move us on, though, Andrew, I see your hand up.
Yeah, thank you, Barrick. This is Andrew. Just to kind of put a little finer point on this as well. Before this call, I did some research into some of the other aspects of the Colorado Anti-Discrimination Act. And just to clarify, emotional distress damages are available in employment actions and in housing situations. So the area where they're not is accommodations, public accommodations, so businesses and public entities, which is the government. And that's really the limited universe we're talking about.
I appreciate that clarifying point. Thank you, Andrew. Before I move us into our next big substantive conversation, anybody hear anything that raised new thoughts for you or raises a new request you'd have for us of the information you'd like to have as we do move in subsequent months into putting recommendations on the table? Okay. Then today's conversation, where we're going to start brainstorming, and as we did last time, my ask is going to be a couple-fold. One, your current thinking around this. Two, the research that you would need to inform it, or the other experts outside of just stakeholders with lived experience, the other experts you'd like to hear about. And this is a conversation around caps on damages, and the general notion that a lot of these limits were set 30 and 40 years ago. And do they need to be revisited? Do we want to look at how they are tiered here in Colorado? And Andrew, I've got some things that Ian shared, and I've done some of my own research, but I am going to ask you to step in and correct me because I'm not even going to play a lawyer on TV. I'm just going to read some things that I've pulled together. Every state looks at this differently with the backstop of the federal Title VII. In Colorado, when we're talking about claims for discrimination, Colorado has the following limits set forward in our law. The combined total for compensatory and punitive damages, and we're talking about against an employer in these numbers I'm going to read is $10,000 if there are 1 to 4 employees, $25,000 if there are 5 to 14 employees, and then above 15 it goes to Title VII. And by my research, and Andrew, tell me if I get any of this wrong, for 15 to 100 employees, those limits go to 50,000. For 101 to 200 employees, 100,000. 201 to 500 employees, the combined punitive and compensatory damages go to 200. And then for 500 employees or above, $300,000. So that's where Colorado is we name in our law for those smaller numbers, the 1 to 4 employees and 5 to 14, and then we refer by statute to the federal limits. Andrew, am I getting all of that correct for our discussion?
That's correct as far as employment. Yes, sir.
Okay. So let's start the discussion on the employment caps, and then we'll move into some of the others. And I would just invite everybody to react to, first, the tiering of it, and second, the amounts. Are there things that you want to put on the table that you think we need to explore making recommendations on? Are there things you'd like to learn more about on this front? And Andrew, I'm going to pick on you as the lawyer who I know has done a lot of advocacy and work on this. Your thoughts or things you think the group should know on this topic?
Yeah, so first I just want to elevate a point that you'd made earlier that Colorado law applies to 1 to 14 employees. Beyond that, it does go to the federal, the federal law. So essentially what that means is with respect to places that employ 15 or more people all the way up to, thousands of people, Colorado, what we can do in Colorado is we can go above those federal limits. We can provide greater protections, but we can't go below those, or if we do, they're essentially ineffective. So really the core that we're talking about is the 1 to 14 people. As just kind of a matter coming from where I do, I understand why it's tiered the way it is. Generally the number of employees you have is an indication of your own economic base and, how much you might be able to absorb as a business. But again, kind of going back to my earlier point about emotional distress damages in the first place, if you're coming at this from the perspective of someone who suffered emotional distress as a result of employment discrimination, it doesn't really matter. The harm to you is the same. So, personally, I would like to see the recompense for that harm be the same, regardless of the number of employees, whether we're talking 1 or 14.
So let's put that notion or that concept for discussion to the full group. And I am going to go around and I'll go in reverse order, which is going to mean Courtney and then Cindy. And my question to you, when it comes to employment discrimination, does the head count at the offending employer matter? Do the revenues of the offending employer matter, or is it the act, or are there other factors that should be considered in what damages can be pursued? And Courtney, I'll go to you first and then to Cindy.
On the one hand, I don't think that it should matter when you're talking about, 2 versus 15 versus 20. Maybe it matters more when you start talking about, hundreds or thousands of employees versus 10 or 20. The lines that they draw are relatively artificial, and I don't think it should matter, because penalizing somebody more simply because they have more employees. If the conduct is less egregious than somebody who's only got 2 employees, is that really proportional or fair in what you're talking about? Because if the whole point is to punish the conduct and or help the individual, it shouldn't matter how many employees there are. Now, that being said, I'm of the mindset that then the cap should all be adjusted downward. Because again, you're talking to some extent about fuzzy damages. You're not talking about hard monetary losses. And that's always a tricky thing as an attorney, as for a jury. That's always just a hard thing in the law to people have said it's hard to wrap your mind around, and it is, because you are talking about this kind of amorphous concept. But I think it really needs to be about the conduct and looking at the intention behind the conduct, and not, gee, how many people do you have or how much money do you make? That's not really, because then I feel like there's there's a tendency or at least it could lead towards like a weaponization of that or an abuse of that, simply because you're looking at the bank accounts or of the offending party or company.
Thanks, Courtney. So Courtney has added one, maybe two new factors, and I'm going to roll with this as I go to Cindy. Let's not yet talk about the actual dollar amounts. We're going to come back to that. Let's talk about the notion and the idea that there should be different amounts under different circumstances. And Cindy or Courtney referenced the egregiousness. Cindy, my question to you is going to be this, and to everybody. Should there be a difference in how much damages can be sought based on any of these factors? The profile of the business, whether that's how long they've been open, how many employees they have, how much revenue they generate, and should it matter the egregiousness or the intent of the action that led to the cause of action for employment discrimination?
So this is Cindy, and there's a couple of things that come to mind. One is when you look at a business, when we talk about 1 versus 14 versus 1,000 employees, sometimes there's that misperception that number of employees has something to do with the net worth of the company. And so there's a big difference between a Fortune 100 company and a Fortune 500 and, lots and lots of small businesses. There are many small businesses that may have 20 or 30 employees, like a restaurant, that are really not that robust when it comes to their net worth. And I think, I guess I'm sort of surprised that there's not more of a factoring in terms of the actual robustness of their how do I want to say, the bank account of the company, what they can actually withstand. Hypothetically, there's a big difference between, going and saying Google was discriminating against me versus, my local person, somebody that was their own business, a locally owned business is what I was thinking of. So that's one piece. It kind of concerns me that there's not more thought to that because the number of staff is not necessarily representative. The second thing, and I think that more concerning, is intent versus egregiousness. Egregiousness reflects impact to the person. And I do think egregiousness should carry a more severe burden, if it's a very egregious act, if you will. But intent puts it to such a high standard to prove. And in some cases, it's very difficult to prove intent, as I've mentioned a couple of times before. I hate to see that piece required. So those are my thoughts.
Thank you, Cindy. And as I'm listening and watching everybody processing, it occurs to me I may have put too much into one question. So I'm going to reverse myself and split these up and have conversations about the profile of the employer. And then separately, we'll talk about the act that gave rise to the action. Lauren, I'm going to go to you. And then I'll go to Tom. And the question is, setting aside what the actual dollar amounts are, we'll get to those coming up. But should the profile of the business dictate the caps, whether that's their headcount, their financial ability to absorb a claim or any other factors? Should those be substantive factors in the damage limits?
This is Lauren speaking. I think my colleagues on this call have already pointed out it's really complicated, and there's no general logical way to answer that. I would assume when they wrote the act and came up with a number of employees, they were probably assuming that the fewer employees, the fewer resources they had. But being married to a small business owner who has about 200 employees, maybe I should say mid-sized business. I mean, there are some years the revenue might be high, but there's zero profits. Everything's going back in the business, and there may not be the resources that some companies have, resources like an HR department or general counsel on staff or even on contract to advise you. So I think you could come at this a number of different ways. It's really difficult to say. That probably when they wrote the law, they were assuming if you had 1 to 4 employees, you're a small business and probably don't have a lot of resources. And the more employees you have, the more resources you have, more opportunities you have to have advisors or do the right thing. But it's not always the case.
Yeah, and I'll get to Andrew, who can probably update us on when some of these numbers came to be, but I believe a lot of it was before we had things like the .com revolution and different issues. Andrew, do you know offhand when some of these numbers were established or updated last?
You know, I couldn't tell you offhand. I'm working on getting it up on Westlaw, and I'll chime back in if I'm able to find anything.
I appreciate it. Let me go to Tom and then Alana and Andrew. I appreciate you letting me always put you on the spot like that. Tom, if I discriminate against somebody in my employment practices, should how many employees or how profitable or not, or how much revenue or how many offices I have, should any of that be a factor? And if so, without getting me specifics, what should that look like?
Tom Aker, right off the bat, I would say yes, it should be a factor. I think they both should be a factor, but I agree with Lauren that sometimes it's not the size of the company. You might have, especially nowadays, as you mentioned with the .com economy, that you might be a real small company but very profitable. I think, and I don't know the how, but do you look at ability to pay along with what the act was? I don't know if that's a solution or something to think about or not. So, but I think it's a combination of factors. You just can't rely on one factor.
Thank you, Tom. And the good news for all of us today is I'm not asking everybody to answer what it should be today. What I do want is for all of us to start thinking about the complexities of it and what are the pieces that we're going to need to put on the table to start answering that in our upcoming conversations. Alana, your thoughts? I have 5 employees or I have 200. I barely break even or I'm raking it in. Could any of that be a factor if I discriminate against somebody in employment?
Thanks, Brad. Yeah, this is Alana. I think I kind of agree with what the others are saying, and that employee count may not be the best way to measure that because, yeah, I'm just thinking about the many small businesses I worked at, especially going through college and everything like that. And the owners were generally wonderful people who they were lucky if they were paying rent on time, much less paying attention to any of the broader scope of things. And they did have many employees, but yeah, they were just trying to stay open month to month. So the employee count, I think, is not the way to do it. Whereas resources, if they're making bank, they have the resources to look at the laws and make sure they're doing everything right, and having the impact that they should be having on the community around them. And I think that becomes much more important, not from a punitive sense, but from if you can do it right, you should do it right. And if you have the time, energy, or resources to make that happen, it should have happened before the law has to come enforce it for you. And I think that's that. I don't remember if we're talking egregiousness versus intent as well, or if that table.
I'll get to that in a couple of minutes. Yeah, and
then perfect.
Alana, I appreciate that, and I think in between the lines, what everybody is saying, you're teeing up that industries all look different. Does a small venture capital firm look different to you because they have 5 employees than the neighborhood restaurant that employs 30 people in the kitchen? I don't know. Andrew, let me go to you and then to Cindy.
Thank you, Barrick. This is Andrew. Just based on some quick research, so don't take this to the bank, but the state law was amended in 2013 to include those caps on the employment for 1 to 14, and frankly incorporate Section 1981, the federal law as well. Looks like the federal law setting the limits from 5 up to the unlimited number was in 1991.
So as with the ADA on those limits being 1991, we're now looking 33 years in the rear view. Cindy, your hand is up. Jump in, please.
Yes, well, I was just thinking, something to reflect on as I was listening to folks, and Tom said, really well said, in terms of looking at the company's ability to pay, which I think when we talk about the number of employees and or how much profit a company is making, that's really what we're attempting to get at. However, I think we need to weigh in and make sure that we really consider that even if we build in the ability to pay as a consideration, that it is only part of the consideration, and that we find a way to lean towards egregiousness of the act. And I'm saying this because, if you think about it from the standpoint of most employers, I think, really try hard to do the right thing. Sometimes they don't, out of, just misinformation, et cetera. But there are some that are blatantly discriminatory. They know what they're doing. And, for them to not have much of a profit and be able to say, well, I know we don't really have to worry too much, even if we get caught on X or Y or Z discrimination issue, because nothing can really happen to us. If we built the law around strictly ability to pay, for example, I think we have to consider that potential impact.
Thank you, Cindy. And let's go ahead and pivot there. Tom, I'm going to go to you first and then to Alana. And we're going to set aside now for a minute the conversation about the business profile, whether headcount or revenues or net profit, and talk about the act itself. To what extent, if at all, should the egregiousness or the intent matter in what damages can be sought? And for clarity, to make this a little more tangible, if you have thoughts on that, what makes something more egregious or what differentiates on the intent?
This is Tom Aker. I would say Cindy said it well. As far as, their intent or their ability to know something, or the fact that they just chose to ignore it, I think should be taken into account. If no matter what size a company is, if they chose to really ignore, or is it just hey, we didn't realize? I think that should be taken into account. And as Lauren mentioned, maybe it's also, should they have spent the resources, because they do have the resources, to find out what the law is and how to work with the law. So it's kind of threefold in a way.
Thank you. Let me go to Alana and then Lauren. How much should the act itself be a factor in the damages, whether that's intent or the egregiousness of the discriminatory act?
Yeah, this is Alana. For me, I think I also really liked what how Cindy said it of I think intent is too high of a bar. We can never be in somebody else's head to know exactly what they meant to do or what they were thinking or why they did something. But the egregiousness of the impact and how, I guess, how much of an impact it had on the person seeking the damages, I think that matters quite a lot. And also kind of a common sense perspective of, should the person have known better who caused this impact? Is this something really obvious where they should have had that wheelchair ramp in years ago and there's no good explanation? Or is it something that maybe it's a learning curve and it's understandable that they didn't know, now they do and need to fix it, but less, I guess, more understandable for why they would have done that wrong. Not the greatest wrap up.
No, thank you. Lauren and then Andrew. The act itself and the extent to which it should be a factor in the level of damages that can be sought.
Hi, this is Lauren. Now off of mute. But again, it's so complicated. I don't think there's a black and white answer. I mean, there is. We already acknowledged that in the law. You know, if I'm driving and I hit ice and I'm driving under the speed limit, but I've hit ice on icy roads and I cause an accident, a fatal accident, you know, it's still the cost of a life, the ultimate price. It wasn't intentional. I wasn't doing anything illegal, or I was using caution. And we'll treat that differently than someone who gets behind the wheel of a car and is road raging and driving under the influence and causes an accident that results in a fatality. Which that's a really extreme example, I think, but I think there is a difference. And you know, are you doing the right thing and acting in good faith? Everybody makes mistakes, and you know, sometimes getting back to the notion of employees and the number, the more employees you have, the more opportunities you have for those employees to make a mistake too. So in any case, there's not a good black and white answer for me there, except that I think we already treat that in the law from everything I know, not being a lawyer, but your intentionality, your lack of or your disregard for the law, or lack of attention to details, are factors and the way we treat a violation of the law.
Thank you, Lauren. I'm going to go to Andrew and then Courtney. I also want to just give everybody the grace and the comfort of not having a perfect answer. This is not an easy question. If it were, the legislature wouldn't have punted it to all of us to try to figure this out. This is complex, and I just want to honor all of you being candid in sharing your thoughts, however fully or half developed they are. And I want to recognize this is difficult. And today, we're not trying to answer what to do. We're trying to address what are the factors we need to be looking at. Andrew, to you, and then Courtney, to what degree should the act and the actor behind it and their behavior be factors?
Thank you, Barrick. This is Andrew. I, like so many others, agree with a lot of what Cindy said. You know, one, I don't think intent is the proper standard here, especially because when we're talking about disability discrimination, there often isn't the intent to discriminate. It's you didn't do something right, you built something wrong, you failed to follow a policy. It's not because you had ill will. So I don't think intent is the right standard. I do like the discussion though about egregiousness, and like Cindy commented, it does cover a lot of different factors that we all seem to agree should go into the overall analysis. But much like you said, it is a fuzzy standard still, and you know, kind of shades of Courtney earlier talking about emotional distress damages in the first place. It is very much a fuzzy standard what we're talking about. It is very fact specific, but that kind of reminds me of something else we were talking about earlier, is how juries operate. This is what a jury does, is they take this amorphous standard, they look at the facts of what happened, they look at whether the actor had, you know, particular mens rea, so to speak, the intent or not, or what degree. They look at how bad the harm was that the person suffered, and the jury comes up with a number that is eventually cabined, and the jurors don't know about the limits on damages. They're not told about these limits, as Ian mentioned in previous meeting as well. So the jury comes up with what they think is a fair amount based on this fuzzy standard, and awards that. So, you know, some of me is saying we maybe don't need to change the standard so much. We just need to make sure that those damages are available in the first place. And, you know, again, they are available for employment and housing, and we want to make sure that they're also available for accommodations.
Thank you, Andrew. I'm going to go to Courtney and then Cindy, although you teed us off, I think it was unintentional because you kind of segued us into it. So after I go to Courtney, Cindy, I'll come back to you for thoughts. Courtney, the question on the table with everybody is, should the intent, should the egregiousness be a factor in what level of damages can be awarded?
So I think, I mean, when I was using the word intent, when I was talking earlier, I mean, there's a whole spectrum of mens rea, like that was just discussed. I mean, in terms of your mental state with this and in the action that occurred. And I think intent can be a factor, because I think, I mean, certainly intent is part and parcel of a lot of different offenses out there, whether criminal or civil. And so it's certainly something that can be looked at, and obviously there has to be evidence to support it. I think in the employment context, you certainly could have somebody who's acting intentionally. Somebody an employee makes a complaint about discrimination, puts the employer on notice, employer doesn't do anything about it, they continue to treat that person the same way. I think you can start to build a case for intentional actions. So I don't think it's necessarily outside the realm of possibilities that it's could be considered as part of this. But I also think that there's intentional, did the person have knowledge? Were they acting willfully? Were they acting recklessly? Were they acting negligently? I mean, that starts to touch on, I think it was Lauren who was talking about, the car accident. I mean, there's a whole spectrum of different mental states that can go into this. And I think those are all things that we need to talk about. And, you start getting into intentional, then you start getting into like punitive damages, as opposed to just your emotional distress damages. It's the demonstration of intent or the proving of intent that leads you to start dabbling in, the punitive, the really big damages. And I think that's a different piece of this than what we're talking about with the emotional distress. I think one thing though that sort of came to mind is I was listening to other people talk about it, and I was thinking about is, when you're talking about the employment context in particular, when you're dealing with employment discrimination, an employer discriminating against an employee, there are certain factors that may be more relevant to look at, such as size of the company or their what's their P&Ls and things like that, because you're talking about an employer who's employing a person, it's a position of trust, and then they're discriminating against that person. So I think it creates a different relationship between the person who's being discriminatory and the person who's being discriminated against than somebody who perhaps goes into a place of public accommodation where there isn't that same level of relationship or understanding between the two parties. And so I do think it creates a slightly different context that we're talking about here. And that was just something I wanted to throw out. I don't really have more thoughts beyond that.
Thank you, Courtney.
Mhm.
Cindy, you started us. Bring us full circle or additional thoughts. How much should intent or egregiousness be something that we put on the table as part of the consideration of the amount of damages that could be awarded?
So this is Cindy. Well, there's a couple of things, first of all, I just as a background, I spent a number of years processing unemployment claims, which really goes to looking at who is the moving party, who has the control of the decisions that were made, and then looking at the impact of decisions that were made. And I think what concerns me about the intent piece is that intent doesn't tell us how much control that a person has or a company has in the decisions that are made. Sometimes discrimination happens and it's severe, but the control wasn't necessarily up to the employer because maybe they had to go through, certain zoning, or who knows, there were certain decision makers that were outside of them, or maybe they needed to get in certain supplies or equipment that didn't come through. So they didn't necessarily have control of some of the circumstances. And so I think I am concerned that we, maybe take a look at not so much intent as who has control, how much control did the employer have? And then egregiousness, I'm really glad to hear that. That would be, something that folks would consider. And I think that egregiousness goes to special circumstances. There are really, really severe, sometimes severe impact to individuals that falls in the area of egregiousness. And the trick is going to be how to define an egregious level of discrimination, but it is so important because when it is egregious, it sends a message that, if we don't treat this differently and if we don't give more weight to it, then again, we're making our our discrimination laws ineffective. I should say anti-discrimination laws ineffective. It's a big difference between, it doesn't really matter if somebody turns over in the process of driving a cement truck and they turn it over. It really doesn't matter whether they intended to do it or not. The company, in this case, is going to be impacted by tens of thousands of dollars. So I guess, it's just important that we not spend so much time on the intent of it.
Thank you, Cindy. And Cindy, I'm starting to feel like you've got my inside notes because you picked the perfect way to segue us into what is my next piece of this question. You mentioned how much control somebody has. And on this one, I'm not going to call on everybody. I'll open it up to people to raise their hands. But the question I'd like to pose before we start talking about how to determine amounts, what are the other factors, if any? We've talked headcount. We've talked revenues or profit. We've talked egregiousness. We've talked intent. And I'm not saying we've agreed on any of those. Those are just the things we've put on the table that we need to be able to bring some information to all of you to talk about. Are there any other factors when we're talking about a discrimination claim that you think should be part of the calculus that a judge ultimately uses in awarding the damages, knowing that as Andrew pointed out, the jury isn't told all of these pieces. But are there other factors that you think we should put on the table for discussion when we dig into workshopping your recommendations on what these limits should be? Nothing else jumping in people's minds. Maybe we've complicated it enough. I will leave it open, and I will, for our future conversations and for today. If something comes to mind that you say, hey, I think if that company is based in New Jersey, but has an office here, we should consider that. Or if you think that the industry they're in, anything on the table. Let's pivot a little bit, though. The other big question is how to not only assign what the limits are, how to adjust those limits as time goes by. Do we wait for legislative action? Is it tied to, we've seen in legislation amounts tied, and I'm not just talking about discrimination, but when we make adjustments, it's everything from the cost of living to industrial goods to other factors connected to the economy. What, if anything, should we be considering in how the amount is set and how the amount is adjusted over time? This one, I will go around the table, and Andrew, you're going to get called first on this one. We've got numbers that were set somewhere between 1991 and 2013. They're 11 years old. They're 33 years old. What should we be thinking about when we set them, the frequency with which they're adjusted, and how they're adjusted?
Thank you, Barrick. This is Andrew. I'm by no means an economist, so I may be getting my verbiage a little screwy here, but it seems that tying it to inflation or the rate of inflation, something like that, would make the most sense, because that's what real dollars actually seem to amount to, in terms of actual spending power of, your average person living in the economy of whatever period of time it is.
Fair enough. Let me go to Alana and then Courtney. Any thoughts? And again, we're not trying to answer it definitively, but what should be the things on the table for our discussion when we do workshop this, of how we determine what the initial amount is for each of these tiers, if we're going to have them, and how it gets adjusted with time?
Yeah, this is Alana. Yeah, I'd echo what Andrew said of tying it to inflation seems, or unless there's a better economic metric, but whatever helps tie the like real value of money so that this rises, I guess, with the tide. And I'd say update it annually. Just automatic calculation seems like a safe standard.
And Carrie may kick me under the table later, but I'm going to suggest this may be a place for some research to look at what are the historic awards that have been given and what do we know about the adjustment in rates, whether that's inflation, cost of living, cost of durable goods. I think there's a lot of, in the economy we've had the last, since really 2008, we've seen some divergence between cost of living and inflation and other factors. Andrew, before I call Courtney and then Tom.
Thank you, Barrick. I was trying to find this before answering, and I just did. So in Colorado law already, there's a limitation on damages for non-economic loss or injury. So essentially emotional distress. That's 1321-102.5. And that, in fact, does tie it to inflation. It looks like it's calculated every 10 years. What it says is limitations on damages set forth in the preceding section may be adjusted for inflation as of January 1st, 1998, January 1st, 2008, January 1st, 2020, and each January 1st, okay, every 2 years thereafter. So it looks like there's already a Colorado law that ties a cap to inflation, and perhaps we can piggyback on that.
Courtney and then Tom. Any thoughts you want to layer in?
Yeah, I mean, I think that the statute that Andrew just read, that makes sense to sort of follow something like that. I don't think it can just be an automatic, inflation goes up by this much in 1 year or 2 years, and therefore these caps that we're suggesting are also going to go up. I mean, I don't think it should be an automatic thing. I think that's a guiding factor that can be looked at, based on those, whether it's 10-year, 5-year, 2-year, whatever intervals. But I think there needs to be like further analysis and just an automatic, rubber stamp on that if it's gone up X, therefore these caps are going to go up X as well.
Thanks, Courtney. And to be clear, I'm not trying to push on anybody to answer that this should be our adjustment formula, but rather what should be on the table, because in the next couple of months, this is going to be one of those discussions where we do get really wonky, and we're going to look at all of the factors you're naming and what are the recommendations for the amounts of damages and how those are adjusted. Let me go to, I think, Alana, I was calling on you next. Is that right? No, Alana's like, Barrick, not me. Tom, thank you. Tom and then Lauren.
I would agree. Tom Aker here. I would agree with Andrew about this and Courtney about the state statute, but I often see it tied to geographical area as well. That the cost of living or the inflation in a rural area may not be the same as in a mountain area. So is there a way to tie geographical location as well? And I don't know the answer.
Yeah, and to be clear, we're not trying to judge or vote on any of it, but I'm hearing everything from inflation to COLA, the cost of living, to are there some regional factors? We'll put all of this on the table when we try to put this jigsaw together. Lauren and then Cindy.
Yes, this is Lauren. I have heard that sometimes CPI is used, but I think if it's already spelled out in Colorado statute, it looks like that there's an opportunity to review it every couple of years now. Did I understand that correctly? It was every 10 years until 2018. Is that right? And now we're on every 2 years. And that, if it isn't already set in statute with that calculation, that's something that legislators, that we're paying them for the job of taking those all of those factors into consideration.
Thanks, Lauren. Cindy, the question to you: what should we put on the table as we assemble this giant 3D jigsaw of the amounts of damages, what should be factors that we should talk about in how those get adjusted over time or how they get set?
So this is Cindy. I'm not an economist either. Well said earlier, but I am concerned that, number one, this is only changing every 10 years because one of the factors that I don't think inflation takes enough into account is changes in minimum wage. So, I started work after I got my master's degree way back in the 80s. Now I'm dating myself, but I started out at $7.39 an hour. And today, I could go get a job at McDonald's and I'll probably make 22 an hour, and I don't have to have a degree at all. I go to this because when you look at the fact that someone such as myself, I might get awarded $25,000, the intent is that I do something with it to help fix the problem or in some way help me move on past whatever has happened to me. If I need to hire people, I need to buy things to make that happen. I might have to hire a therapist or whatever it is that I need to do. And the cost of the changes in employing someone are so significant over a 5-year period that it's amazing to me that we don't have this recalculated on an annual basis. So I do agree that cost of living, geographic area makes sense, but also definitely looking at minimum wage as well as, inflation rate, when you have to buy equipment or other things is important.
Thanks, Cindy. We're going to put a whole lot of these ideas on the table when we come back to this spring. Just as an administrative note, we are at 12:35. We are scheduled by agenda to have public comment at 12:45. If there are members of the public, I see somebody who is just on here as iPhone, which may be staff sneaking on. It may be a member of the public. If you are a member of the public, I would ask that you send me a message. It's the one time I will ask you to use the chat, letting me know you'd like to speak at 12:45, or at that time I will ask again. Otherwise, I will continue to use all of our time for us to continue this discussion. And I'm going to take it from here to who else we need to hear from. And what I'm going to ask you is, we've identified a lot of the pieces we're going to put on the table, whether that's employer profile, whether that's the nature of the act, whether that's different financial and economic factors. What I'd like to ask, in addition to the research that Carrie and I will extrapolate from this, we need to bring you, is who do we need to go ask their opinions on the same questions, or who do we need to get to respond to different things? So, two-part question. Who would you like to see us go survey, interview, do a focus group with, specifically about the issue of the caps? I'll come back to it on the emotional distress, but on the amount of the awards, who would you like to get input from? And if you have an idea, what's the question you would want them asked? Alana, I'm going to put you on the spot first just because I haven't yet today. So I'll go to Alana and then Courtney with this question on, when it comes to setting the amount of damages, who would you like us to go get some opinion, some perspective, some experience from, and what would you like us to ask them?
Yeah, this is Alana. I think I know we've mentioned learning more about jury verdicts and results in the past. I think that's a big one for me. And then also possibly if there's disability advocate groups this is one of the things they're actively working on. Usually advocacy groups do a lot of very specific research into whatever area they're trying to improve, right? So if there's a group focused on that, I would be interested in hearing what they have to say.
I'll go to Courtney and then Tom, and with the understanding that we're keeping track of the research, and we will bring that. And Alana, I know it wasn't exactly where you were going, but it's a reminder to me to touch base with a lot of these orgs about what research they already have that they can share. But setting aside the research and really talking about opinion, whether that's the opinion of attorneys, business owners, people with lived experience who have been discriminated against. Courtney, who would you like to see us survey, poll, interview, do a focus group with? And what would you want us to ask them that could help inform our discussions about how we're going to take all of these pieces and put together a cohesive recommendation?
I mean, I think all three of those groups that you just identified are important to talk to. Lawyers representing both sides, business owners, people who have been discriminated against. I think those are all important to talk to, because all are going to have different perspectives about, you know, what this really looks like and how it impacts them, you know, not just individually, but with representing that particular segment of the population. I think, you know, if there is maybe not individual business, maybe some individual business owners, maybe chambers of commerce, I think it's important to talk as well to maybe like city planning or building divisions, or county for that matter, depending on you know, given municipality, how you know, certificates of occupancy get issued and things of that nature. I think that's important because I think there's a big knowledge piece here. I think there's a lack of knowledge is a big thing, and that's going to become a factor that goes with the damages discussion. But I think that that's important, that a lot of times there's just this lack of knowledge and people being under this misunderstanding of, well, gee, I have this property and it's open and I have these certificates, therefore I must be doing everything right, and not realizing that they aren't. And so I think that that's an important group or part of segment that we should be talking to as well. And maybe even you know, experts who handle you know, accommodations and make properties compliant, you know, talking to them about it's really easy to say, well, gee, it's this business discriminated and they should have done better and they shouldn't have done this. And then you start looking at the cost piece of what that means to make your business compliant. I think that would be informative as well, to balance out the discussion.
Thanks, Courtney. Tom, to you, and I'm going to ask you to weigh in on who the people are or the groups, and you can name a very specific, or you can say, I think it's this group of folks. I'd also love your thoughts on what question do you want Carrie and I to go ask them that the combined volume of their answers is going to help you think through our recommendation on these caps and on modernizing these dollars and on pursuing damages.
Thank you. This is Tom Maker. I agree with the groups that Courtney identified. Those are the ones that were on my mind. I think I might add building officials, because they deal with a specific code that may be it's set at a national level that people adopt. So, you know, I think we'd have to have all the groups that she mentioned look at that as well, and how it would be adjusted specifically for Colorado. As far as a question or some questions to ask, I would ask one, what do they know about the damages now and how they're set, and are they working? Because you're likely to get a wide variety of answers depending on who you're asking that question of, but it'd be great to kind of hear what's working and what's not working for like a client that has been discriminated against versus a business that's been discriminated against.
Thanks, Tom. Let me go up to Andrew, and then Cindy, and then Lauren. Andrew, who should we talk to? And it may be surveys, it may be focus groups, it may be whatever. Who should we talk to? And what specifically should we ask them or try to elicit the input of?
Thank you, Barrick. This is Andrew. I'm actually going to start. I've got a couple of clarifying questions for you / the group. So far, we've only talked about caps in the employment context, but I've heard a couple of other people talk about, you know, accommodations. Housing, for instance, has its own separate caps that are tied to the number of times you've found to have discriminated in the past 5 years. Are we going to have separate discussions about each of those, or are we just kind of talking about caps, you know, overarching everything?
No, I thank you for the clarifying question. We are going to have conversations on each of those because they do have these multitude of different factors as you just highlighted.
Great. Thank you. So getting back to the question, in addition to some of the others that folks have suggested, who I agree those are good suggestions, building departments, things like that. I don't know if we'd be able to, but if we could get, a trial court judge or two, or even an administrative law judge who has the practice dealing with these statutes in particular, who we can maybe ask some questions about, jury service, what the jurors consider, things like that. And get some information that'll give, members of the group, including myself, more comfort in what we're doing. Also how it really works in practice of not telling jurors of these caps. Does that seem just in their opinion, and how that works out, and maybe just some things that we may be missing that they routinely consider that we're not thinking of. I mean, I for one don't practice in the employment area, so I know a little bit about what I'm talking about here, but this isn't necessarily my wheelhouse. So there's easily things that could be sneaking by that I just have no idea what I'm missing.
Thank you, Andrew. Cindy, and with the note that we'll come back and we're going to dig deeply into what are the factors around things like housing discrimination claims. We've talked about where there isn't even the room to seek those, but through the lens of today's conversation on some of the caps we identified, particularly around employment discrimination claims. Whose perspective and experience would you like to bring into the discussion or help inform it? And what would you want asked of them?
So this is Cindy. First, I want to say Andrew went exactly where I was planning to go, having to do with having, the criminal justice system, if you will, weigh in, the judges, giving information to us in terms of questions. I think, what do the judges who hear these cases, and then beyond that, appeals judges, what do they see in terms of working, and what makes it difficult to make decisions in these sorts of situations? Specifically, my guess is that judges and folks who hear appeals can help us identify what's not working and what prevents them from making perhaps a more fair decision. Part of it may be information that the jury is considering or the instructions that are given to them. But I'm sure that part of it too has to do with some of the gaps in the law that we're not thinking about, that they're having to sort of work around or attempt to work around on an everyday basis. So I'd really like to see that. I'm glad to hear that we're going to spend time on specialty areas, because obviously employment law is a whole different ball of wax than considering housing, for example. I'm concerned that we may not have enough time to consider this if we only meet once a month, but I am glad to hear that we are going to do that, because these are very important and very different issues.
Thank you, Cindy. And full transparency on 2 points that you and Andrew collectively raised. One, we're not going to be able to if we only meet once a month. I wasn't going to go there quite yet, but one of my asks of you is going to be, we're going to need a few months over the next 4 and 5 where we meet a couple times to get this work done. I'm not going to let us rush through any of this, which is going to mean some extra conversations. My other point of transparency, you brought up one, a few of you did now, that I had not at all anticipated, and that is, can we get a judge to talk to all of us? I don't know. I haven't asked, but I will. And I don't know if we can get them to join as a guest, if we can get them to answer some questions and bring them back, but we will get to work on that for you. I certainly understand, listening to everybody, how valuable that could be to understand what's going on under the robe and behind the curtain, and how this all turns out. Lauren, to you, before I start moving us to where we're going to go next, who would you like to hear from, particularly as we're talking about employment discrimination claims, and what would you want asked of them, whether it's on a panel, a focus group, or just through surveys, to help inform your thinking and our conversations?
Well, I think the group just about covered it all. I think maybe the only thing outstanding in my mind is maybe insurance companies, and as caps increase, how do rates increase for all? And what's the impact? And more importantly, that I think we would all agree on, or what are the outcomes? Does it improve the outcome for our constituents or not?
So
And that might be a really tall order.
I think that this goes back to what I said 15, 20 minutes ago. This is not an easy task that you all have volunteered your time to help tackle. It's an important one. It's not like we're going to get the research and it's going to show us 4 + 4, so we know the answer is 8. The answer is going to be there's gray, there's blue, and there's crocodiles. And what are you making for breakfast? I don't know. And all that to say, this is a very complex issue. I'm not seeing any members of the public, which means rather than let you go, I'm going to keep picking your brains a little bit. I want to stay on this topic because it's really important to me and to the team here that we get you as robust input from additional perspectives. So I want to keep on this, who to talk to and what to ask. And I want to go back to our earlier conversation around seeking emotional distress damages. Who would you want to hear that would help shape that? And what would you like us to ask them? Is it plaintiffs? Is it defendants? Is it judges? Is it some of the same folks? Who would you want to hear from or get input from? And I want to be clear, this is not always going to be you hearing from them live. Some of it may be we try to survey large groups or organizations. Some of it may be people submitting testimony in video or written format. But on the topic of what should Colorado do about allowing the pursuit and the award of emotional distress damages in the post-Cummings world, whose opinion and experience would you like, and what should we ask them? Cindy, I'm going to go to you first and then to Courtney.
See, all right, so this is Cindy, and I guess what I'm thinking is that at least maybe reviewing some research, if there is any, on some of perhaps the more higher profile or particularly impactful cases, which of course would be determined by who's doing and directing the research. But I'd like to hear from the side of the plaintiff and their attorneys, from the defendant and their attorneys, and also, if possible, if there is that information, any information that we can see from the standpoint of the judge, whether that's their written decision and or if there was an appeals, what that looks like. So I'd like to just see the full case. I'd like to see that, for employment for at least 2 or 3 cases, as much as we can get, just to kind of help stretch our mind in terms of helping us best identify the gaps and get a really robust picture.
Thank you. Courtney and then Andrew. On the subject of emotional distress, who should we solicit thoughts, stories, ideas from, and what should we ask them?
Yeah, I agree with who Cindy identified. It might be helpful too to talk to like there's people out there who get hired as experts to testify at trial about damages and are really good at quantifying and doing that analysis. And it might be helpful to talk to some of them about what they're tasked with coming up with numbers. And they're doing it on hard damages and, emotional distress, all those different things. And I think that they might have an interesting perspective because it's kind of how their brains work and what they've done.
Thank you. Andrew, and then Lauren, emotional distress, who and what do you want to ask them?
Thank you, Barrick. This is Andrew. First, I want to start by reframing this question just to make sure we're all on the same page that employment and housing under the Colorado Anti-Discrimination Act already allow for emotional distress. So when we're talking about emotional distress damages and whether to allow them in the first place, we're really only talking about public accommodations and public entities. To that end, I think having people with disabilities who've suffered discrimination, whether they in fact filed suit or not, the stories of people who've decided not to file suit can be equally as compelling. But people who've suffered discrimination based on disability, and then also hear from the business community in the various sizes, small business, medium, however we may classify that, and potentially large employers as well, or large businesses as well, and find out some of what it is that has gone into creating their business and how they get information about how to comply with laws. Like, for example, I don't think there is anyway, any particular course that a business owner has to go through to learn about tax laws, but they're still expected to pay their taxes, and not make any mistakes with that, and otherwise they face penalties. So kind of find out what some of that guidance is that they've gotten as far as avoiding disability discrimination, and see where we might be able to make that a little bit more robust as they're going into things, to provide that knowledge up front.
Thank you, Andrew. And I appreciate you reminding all of us, as I speak so quickly, that we're talking about a specific subset here of claims around accommodations. Cindy, I see your hand up, so let me get to you, and then Lauren and Tom on this issue of emotional distress damages related to public accommodations, and who we would want to talk to and what we want to ask them.
Yeah, this is Cindy, just real quick. I don't know why I didn't mention this before, but I'm wondering about contacting someone with the Denver office of the EEOC, because they do handle, particularly in employment, a lot of these types of things. And I personally take a lot of their seminars and find them particularly helpful, but I wonder if they couldn't help us weigh in with an expert.
Thanks, Cindy. Lauren, your thoughts?
I don't think I have another group that I would add, but I would agree with the suggestions made so far by everyone.
So one of the things with so many smart people, by the time I get through 5 or 6 of you, it's tough to have another one. Tom,
That's right.
And then I think Alana disappeared from my screen. I think she's still with us though. Tom, your thoughts?
I, like Lauren, don't have anyone that comes to mind on who we should add.
We've got healthy lists going, so I'm sure the team will not miss adding more. But Alana, if you've got thoughts or thoughts on the questions we would want to ask people about seeking emotional distress damages related to public accommodation.
Yeah, this is Lana. I don't know that I have anything new at the moment, but I do want to echo or second Courtney's idea of having a damages estimator. I really liked that. I thought that was a great idea.
Fantastic. We're at 5 minutes until the hour. I still don't see any members of the public. I have a sneaky suspicion that iPhone is one of our staff folks. Tom, you have a hand up. Jump in.
The only thought that just came to mind is, and I don't know if this group exists, but is there a group that provides assistance once someone needs help with emotional distress? Is there a group that helps them?
I don't know the answer. I will check in with some of our task force members and our advocates and see if I can find an answer for you, though. I had said at the top that we were going to do a little bit of a preview from the other subcommittees. We got to having such a full conversation here, we didn't get there. So I'm going to prioritize that on our next conversation, where we will also, to Andrew's point, we're going to start getting into the housing discrimination side of it. We made the decision to push that one because there is a housing subcommittee that has been wrestling with a lot of questions. They were, so you all know, tasked with identifying what is the current need and inventory for accessible and affordable housing and what is the future need. And they've identified a whole lot of challenges by what do we even mean when we say accessible? Accessible to whom? Accessible where? And is accessibility just about the unit, or does it include when they step outside or roll outside their front door? How much does that all start to matter? That's going to bring an intersection to the work that you all are doing. We may end up with a joint subcommittee conversation about the legal definitions, about the rights of remedies, but we wanted to push that to our next conversation. And they, along with others, are going to be coming back to this group with a lot of things. What do we mean when we say basic accessibility to things like outdoor recreation? How does the definitions that we all have talked about apply to these different contexts? So at our next conversation, we will continue this. we will have gotten some of the research you all have requested, and we'll distribute that in advance. We'll dig into the right to seek claims in the event of housing discrimination, and we'll start to pursue what does it look like to do some of the stakeholder engagement, and what does it look like now once we've put all of these pieces we need to address on the table. How do we start building this into a system and a structure that really addresses the needs and makes Colorado a Colorado for all? I know we've got some staff on the line, so I'll open it briefly if anybody wanted to offer any comments or thoughts. I'm not seeing anybody jumping off mute. So I will thank all of you for the conversation, for the flexibility in going, as this isn't a perfect A to B discussion. Carrie and I are going to get to work with the team at Dora on the research. We'll send out an agenda in advance along with some materials. But thank you all. And if you have more thoughts, as always, drop us an email, drop me a text, just give us a call. We're very frequently available and appreciate all of your continued input. Otherwise, we will see you again at this regular time next month. Thank you all.